Welcome to the webinar, and we're looking at Part 36 cases over the past 12 months. And just a reminder that the PowerPoint should be sent out to you, so no need to take detailed notes. And you can ask me questions electronically via the system we've got here, via the Zoom system, and I'll get to these at the end. And the point about questions I'd like to emphasize, if they could be questions, if you want clarification of some of the issues I've spoken about, it's a bit difficult when I just get general Part 36 questions about ongoing cases. Quite difficult, if not impossible, for me to answer. Part 36 has been interesting this year, particularly in the past month or so. It's been in the news. And there's a series of tweets from Hugh Grant, who was bringing actions for being hacked, phone hacked, and against the Sun. And he tweeted what you call the claimant's dilemma in relation to Part 36. The case against the Sun is settled out of court because News Group, they're claiming they're entirely innocent and of a whole range of things, but they're offering me an enormous sum of money to keep the matter out of court. I don't want to accept the money. I would love to see the allegations tested in court. But the rules around civil litigation mean that if I proceed to trial and the court award me damages even 1 penny less than the settlement offer, I'll have to pay the legal cost of both sides. And that's about £10 million. And I'm afraid I'm shying of that fence. And he makes the point that Rupert Murdoch has spent over $1 billion in damages to claimants in lawyers' fees, settling 1,500 claims in this way. He's remarkably determined there shouldn't be a trial of the facts. And a point I should make, if you're thinking, well, he's made a lot of money, he made it quite clear that the money is going to, he gets will repurpose to groups like Hatdog and to the general campaign. So it's very interesting that Part 36 is being used in that way, and you can see it being used essentially to stop matters being investigated. But that's not a case this year. I think it's just a very interesting example of what's going on. The price you have to pay, I'm afraid, for this free webinar, it's not hardly a price at all. I have to introduce you to the clerks, Kings, they're our two cost clerks, and my two clerks in our chambers in Leeds, James and Lily. I think it just helps if you see people sometimes, if you ever want to chat to them over the phone. So I'm breaking the webinar down today into a number of component parts. So the first part is, have offers been made which are actually valid Part 36 offers? And that's considered in the case of Holden and Holden. And it was a very vitriolic partnership dispute, as all partnerships tend to be, that I've seen. And during the course of the dispute, the defendant had made Part 36 offers. Now, it's important that the court determine whether or not they were valid Part 36 offers, because there'd be a trial of preliminary issue. Now, if there's a Part 36 offer made, the court can't determine the issue of costs until after the trial of damages. So if there's no Part 36 offer made, the court can order costs to be paid there and then. So the issue of whether or not these were valid Part 36 offers was one that was very important. And what happened was that the defendant said, you can't order me to pay costs because I made Part 36 offers, but both parties consented to the court look at the offers with determination of their validity. And what the court said was these were not Part 36 offers. They didn't meet the criteria at all. First of all, the defendant made the offers as if he was the claimant. So that was quite wrong. And the judge said not only quite wrong, but an insuperable objection in itself to have been treated as a valid Part 36 offers. First of all, it offered to pay by instalments, and that's not right, because you must offer, if it's a valid Part 36 offer, to pay in one single sum of money. And secondly, the defendant was making an offer to pay more than 14 days after the matter was settled with acceptance of the Part 36 offer. And again, that means it can't be a valid Part 36 offer. Remember, Part 36 replaced payment of money into court. And the claimant had the guarantee that the money was in court. And the courts aren't going to let the guarantee of being paid in 14 days be watered down by saying, I want to pay in 21 days, I want to pay installments. You could offer that, but it's not a valid part 36 offer. And finally, in relation to this case, there was uncertainty of the offer. And this was a fourth reason not to treat this as a Part 36 offer, because it required a third party to agree to as well. So what the judge said, these were called the bank offers, not Part 36 offers, and I can take them into account generally under CPR 44, but not on the Part 36. And the result in this case was that the court could make an order for costs now, and in fact did so in the claimant's favour. So that's the first issue of validity. The next one, relation to construction and effectiveness of Part 36, was a clinical negligence case of CCC. I'll call it the Sheffield case because it's easier to remember. There was a child seriously injured at birth, the question how much the claim was worth, and the claimant made a Part 36 offer on both the one-off lump sum payment and periodical payments. And the claimant at trial beat her own periodical payments order by $34,140. Now, if you think about that over the multiplier, that's a substantial sum, which she failed to beat a lump sum offer by £133,000. And what the argument was, well, come on, if I've actually beat it in terms of money the defendant's going to pay over by quite a lot, and therefore I should have the Part 36 benefits. But what the judge says was that if you have got a case where you're claiming periodical payments and a lump sum, you have to beat both. And therefore, the claimant only recovered costs on the standard basis. And the other issue about Part 36 offers was one, the case was not about money. And this is the case of Colicci. It was a dispute between families of a deceased person and whether or not someone was bound to transfer shares. And at trial, the judge found that the claimants were successful parties, but the claimants had made a Part 36 offer during the court litigation. So what the judge said was, you're only being partially successful. You only get 40% of your cost up to that Part 36 offer. Well, this isn't a trial about money, it's about rectification. Now, here's the offer. Our clients will offer to pay you the sum of £150,000 by telegraphic transfer, and then it said, for the avoidance of doubt, this is the claimant's Part 36 offer. And what the defendant said, that's actually an offer in relation to costs, and then it went on, if the offer is accepted, our clients are entitled to bear their costs of proceedings, such costs to be assessed on the standard basis. So it's the claimant's Part 36 offer. We'll pay you £150,000, you pay our costs. And the judge found it was an offer to compromise the issue. The defendant said it was an offer to pay costs and said no reasonable person could construe it in that way. There was no ambiguity at all in the way that it was put forward. And the fact that it referred to itself as a Part 36 offer would have put pay to an ambiguity which didn't in fact exist. The offer related to the claim. The claim was the defendant be ordered to transfer the shares. The fact that the claimants could not have been ordered to make a monetary payment didn't stop it being a Part 36 offer. And an offer can take effect under Part 36 even if it proposes an outcome the court couldn't order at trial. And more importantly, from the claimant to defendant's point of view, it was more advantageous to the defendant than the result they actually achieved at trial. The defendant must transfer the B shares to the other claimant. Children will not be paid for them and must pay 40% of the claimant's costs. So the claimants have recovered more, and there was the claimants got the benefit of the Part 36 offers, and the defendant had to pay all the costs after the Part 36 offer on indemnity basis. Now, one issue that's been troubling the courts for quite a while is how do we deal with an offer on liability when damages are still in play? And there's been quite a few decisions we've looked at in previous webinars in this series where claimants have made offers of liability. The Court of Appeal and High Court said it have no effect. Now, the difference about this case of Chapman is that there had been an order for a split trial. And that differs from the case we've looked at in previous years where the liability and damages were still in play. The claimant succeeded in trying the Winston's case. Prior to the trial and liability, it said, I'll accept 90% of the damages when they're assessed. The defendant sought clarification of the offer. When the court came to determine the issue, the High Court, it said this is an effective Part 36 offer, where such difficulty arises in cases like Monday, where liability and quantum issues are tried together. This doesn't apply when a split liability trial has been ordered and the only offer by either party was the claimant's 9/10 liability split offer. So that shows that it's difficult to make liability offers only, Part 36 offers, effective Part 36 offers, where liability and damages are in play. But if you've got an order for a split trial, then the Part 36 will be effective. And again, that's an example because it was very unlikely in that it was an all or nothing case in a lot of ways. Very unlikely the court would have found 10% contributing negligence, but the claimant did better than their offer, and they recovered the Part 36 benefits of increased interest, £75,000, and etc. As a result, beating the offer on the liability trial. And there's been an interesting case, I think, about a late acceptance of a Part 36 offer in a personal injury case. And that's the case of IEH and Powell. Now, over the years, we've looked at a lot of Part 36 cases where the courts have said quite clearly, without a shadow of doubt, if you're a personal injury claimant and you say, there's uncertainties as to prognosis, I'm a child, I'm under a disability, they've said, no, that doesn't matter. It's not unjust for the Part 36 consequences to apply drastic as they are. IEH is different. It's the case where the court said, on the facts of this case, and it's very, very important we have the facts of this case, we're not going to apply all the Part 36 penalties. There's a bit of a sting in the tail. So you see the claimant was a child, had a head injury, defendant made a Part 36 offer in November 2020. It's eventually accepted until 2022. Offer was accepted late, and the question was, should the court disapply the provisions of 3613? So the question is it unjust for the court to make an order? And here we have a child claimant with an uncertain prognosis. It's simply one of the ordinary contingents of litigation, but this was quite extreme. It was a head injury, and the judge said this takes it out of the norm. It's not a normal contingency of litigation. Litigation threatened said is not at fault because they were just exercising their duty to look after the claimant, and the claimant's solicitors acted reasonably. They wanted, if not dispute, the long-term effects of traumatic brain injury suffered by young children are often not known until after the child has gone through puberty. They required medical evidence, and they obtained the updated medical evidence. The steps taken were reasonable. Now, pausing there, I've got to stress that there's a half a dozen Part 36 cases in the past where that's not the test whether the claimant solicitor or defendant solicitor acted reasonably. The test is whether it's unjust. So just the fact that they're taking reasonable steps isn't enough to prevent the Part 36 consequences apply. The claimant solicitor, I think, asked for an extension of time, was never granted. So what the judge said, the normal Part 36 consequences don't apply. So the claimant isn't going to be paying the defendant's costs for the delay between October 21 and 2022. But there's a sting in the tail for this. Although the claimant's not paying the defendant's costs, they said, I'm not sure the claimant's solicitors should recover all their costs, or if any, because of the conduct issues. And those conduct issues were basically failing to inform the defendant of what was going on. And the claimant solicitors in this situation are in a bit of a, I think, a difficult situation, because if they start disclosing evidence that shows that the case isn't as bad as it's going to be, the defendant can always withdraw a Part 36 offer, because a Part 36 offer to a child or a patient isn't valid until it's approved by the court. But there was a general failure to keep the defendant informed. So when the defendant drafted the skeleton argument in response, it says, there's nothing's happened. Nothing's happened since we made the offer, not knowing that the claimant had obtained all these medical reports. So the result of that, says the judge, was that the defendant has approached the application without knowledge of crucial information. The failure of the claimant solicitors was a matter of reasonable conduct, and failure to serve the evidence that was available in good time before the hearing of the application is conduct that's relevant. And he said, if the claimant solicitors are concerned about the Part 36 rules and disclosure, you should have not tried to mix these two applications. If you didn't want to disclose privileged documents to the defendant prior to approval hearing, then you could have applied the approval hearing first and then later had a hearing about the Part 36 consequences. So the court would have approved it. We know the Part 36 offer can't be withdrawn. It's been approved. And then the court consider the next issue. And as a result of that, I don't know the result, but I think you have to be aware that the judge says, I'm not imposing on all the claimant pay defendant's costs, but I haven't decided yet whether the claimant should recover their costs. So the lawyers may have been litigating for 2 years and not getting paid and not getting paid in full for that period. There's certainly a sting in the tail there. And I think the lesson there is it actually remains very, very hard. I don't want anyone to be under any illusion to get a judge to disapply the Part 36 provisions if you're a claimant and you haven't beaten the defendant's Part 36 offer. If you need approval of the court, then seek approval first and then make your Part 36 application to the rules be applied later. The other interesting procedural aspect of Part 36 offers about interest, the case of Smout. Claimant brought an action for damages of personal injury. The defendant appeared without a lawyer, and the defendant was making lots of very nasty allegations against the claimant and his solicitors, trying to extort money, and there were attacks on the claimant's solicitors, and the defendant lost at trial. And the claimant's counsel argued a higher rate of interest should be paid to reflect the conduct of the defendant. And the trial judge agreed with this and ordered interest of the damages, paying and suffering at 6%. And that led to the claimant beating his own Part 36 offer and the Part 36 consequences applied. Now, on appeal, there's only peripherally a Part 36 case, the defendant appealed on a number of grounds, but the fundamental point was that the judge said you cannot use interest to penalise a party for conduct. And the result of excluding the actual interest from the Part 36 offer meant the Part 36 offer wasn't beaten and the Part 36 consequences were still set aside. However, the judge still awarded costs on the indemnity basis from the date of the first abusive letter, and no one was made in relation to the cost of the appeal. So that's peripherally about Part 36, but more realistic, I think, it's about interest not being used as a means of penalising a party's conduct in litigation. And that general question of misconduct, what happens if you beat your own offer, but you've been quite naughty in the way you've been bringing the litigation? Was considered in the case of ABFA. It was actually quite a complex claim. Basically, I'm going to call them the claimant, the applicant, had been subject to an injunction where the party had given undertakings to pay damages if the injunction wasn't justified. And it was found the injunction wasn't justified, so the applicant was able to recover damages. Well, the applicant was, in fact, the applicant for damages were called the claimant. I think that would have reflected in the judgment itself. They sued for a very large amount of money and then made a Part 36 offer of $24 million. A trial, the intervener Petraco, our claimant, they recovered $27 million. And they've been claiming a lot more, in fact. But the point is here, we have beaten our own Part 36 offer. And the judge said, I haven't an unvetted discretion. I can't just decide yea or nay. I've got to look at the rules of Part 36 itself. Here, there had been a dishonest conduct in the litigations, attempt to, over-elaborate or exaggerate the damages the judge felt. And the intervener, that's our claimant, would be penalised in costs. But at the same time, says the judge, I'm going to respect the general Part 36 principles, because the case of Western Liverpool Women's NHS Trust says no matter what conduct or offers, the Part 36 principles are very, very important, that the loser should pay if you've not been a Part 36 offer. So the judge says, I'm not going to give you intervener or your costs. I'm only going to give you 40% of your costs, but that 40% should be paid on an indemnity basis. So indemnity, 100% of its costs on a standard basis up to November 21. And then from a period where the judge felt there was misconduct, on the 10th of July 21, you're only getting 40%, but you're getting them on indemnity basis. And then what about if you've been, as I say, the judge feels there's been misconduct? What about the interest on the damages? I'm going to award US prime of 3%, subject to an overall interest maximum rate of 10%, and an uplift of 4% on the interest payable on costs. Again, 4%, over the Bank of England base rate, subject to an overall interest rate of 10%. What about the additional £75,000 when it's peanuts in the context of the millions of dollars we're talking about here? Well, the judge said there's no reason why the respondent shouldn't pay it. So again, we see a case that's quite tricky and difficult on the face of it, where the court's quite trying to respect the basic principle that the Part 36 principles should be applied. And another case where the Part 36 consequences were considered is the case of Powell and Commissioner for Police, the Metropolis. Mrs. Justice Hill, defendants ordered to pay an additional £54,000 in interest and £10,000 in additional payment, and the costs were paid on an indemnity basis. What happened in Bell was that there was an action, a negligence against the police for allowing, I think, a child to be taken out of the country. The child was abducted. The claimant was awarded £137,000 for damages, and he made an offer which he clearly beaten, and they were well below the offer of damages awarded at trial. The defendant made no offers, so enhanced interest at the maximum rate of 10% should apply to the entire award, apart from a figure for which was actually future losses. And this is very interesting because it was an issue at the hearing itself. The defendant argued that the interest should only run from the date the proceedings were issued, and the judge said no, interest runs from the date of the offer and not the date of issue. So that on the whole of damages. So remember, usually interest on damages for pain and suffering in a personal injury case only apply from the date you issue, but the judge said if you made a Part 36 offer pre-issue, then the interest runs from that date. And then the other consequence of the Part 36 offer was that, it's fairly normal really, the claimant obtained 90% of the budget as an interim payment. So the judge made the point, and again, this is a very important point generally in relation to Part 36. If you pick your own Part 36 offer, then budgeted costs don't apply. This was in the context of the court considering an interim payment 90%, even greater basis for making an award in this case. The court may recover, because of the cost on an indemnity basis, the court legal team may recover costs above and beyond those approved by the court. The limitations of CPR 3.18, I don't remember, apply, and it's likely the claimant's actual costs are higher than those budgeted, not least because the volume of post-trial submissions have been required in this case. So it's another good reason for making a Part 36 offer early. Here we have a claimant making the offer before issue, and it has consequences all the way through in relation to interest. Obviously, consequences in relation to the additional payment, and it has probably a major consequences to cost, because that cost budget can be thrown away because we don't have the restriction of proportionality. What about Part 36 in the case for a claimant who had recovered nothing, or leading to a claimant recovered nothing? And this is that case that was actually reported to me on my blog, Civil Litigation Brief. I think it's just an interesting and important. It's an interesting example of the way that Part 36 applies, and it's probably meant to apply. A peridental claim. The defendant had made an early offer of £35,000, and that offer was not beaten at trial. It was a reduction of the contradictory negligence. It was a dental claim, so I think the allegations were the claimant had failed to kind of follow advices to treatment. And this is the note I got from the defendant's solicitor. The Part 36 offer means the claimant is unlikely to receive any damages. And the claimant was to return the £7,000 interim payment that had been paid earlier on. So rather than receiving damages of £39,000 if the offer had been accepted, the claimant's going to be out of pocket, essentially. Not out of pocket, but because of the effect of quote, the claimant doesn't receive a penny. And that is one of the dire consequences of Part 36 that you've always got to warn your client about. And the other, I said this year, it's been a glamorous year for Part 36. We've had a few grant. We've also had in name the Duke of Sussex. And there's a very interesting decision. Again, it shows this example that Part 36 is real and will come home to bite. The Duke of Sussex and others against NGN. Hacking case. Now, the strange thing about that, although the Duke of Sussex is actually named there, he wasn't actually a party to this part of the trial. The fundamental point here is the number of actions brought, 4 as test cases, 2 failed, and 2 succeeded, but failed to beat Part 36 offers. The other claimants failed on the issue of causation. And I think there's a point here about turning away reasonable offers. Makes the point, Mr. Turner was given another chance to walk away with compensation with all his reasonable costs up to the 25th of March, shortly before the trial, but he did not accept it. The failure to accept the reasonable offer at that late stage and recoup his costs reinforced the conclusion I've reached and requires an order that Mr. Turner pay MGN's costs on the 25th of March 2023, unless I consider it just to do so. I do not consider it just to do so as regard the individual costs of his claim. So again, it says that, it's a real world point, this. You don't beat Part 36 offers, you pay costs, and the costs of that case are going to be enormous. Tempered, I could say, by one part of the judgment later on. Court must order the defendant entitled costs from the expiry of the relevant period, unless it could just to do so. And so it clearly encompasses all the defendant's costs of the claim, and to show injustice is a formidable obstacle. And it's very, very rare. The first case, one of the first cases we looked at where a court made a different order, well, that's quite exceptional, quite unusual. But this whole hacking claim has a number of elements, and there are a number of generic issues which have been tried, and the judge says to the claimants who failed to beat the Part 36 offers, as well as those who failed totally, just because in relation to the generic issues, there have been generic issues tried by a huge number of claimants. I'm not going to award them to pay the costs involved in those generic issues. That's not a usual case, but I think what we can take away for it as day-to-day litigators is that it's going to apply, it's going to bite. People are going to lose their homes, their houses, their life savings if they don't beat Part 36 offers in that kind of litigation. And that's why Hugh Grant backed away right at the outset. It is a very, very live, real-world issue. And then Jones and Tracy, it's again an example of the case we looked at earlier on. It applies where the case is not just about money, and it wasn't unjust for the normal Part 36 consequences to apply. The other case I want to look at is the question about interest. I think defendants sometimes forget this, but it's very, very important. We look at the rules. Equity of safety. The claimant failed to beat defendant's Part 36 offer. It's in the IPEC. There's a bit of a twist because it's in the IPEC, which stands, I should say, for the Intellectual Property Enterprise Court, I think it is. But the first defendant asked me to award interest on its costs. And that's right, it says. You got interest in your costs because that's what the rules say. And I want interest in those costs, says the defendant, from the date those costs were incurred in reference to the IPEC stages. And they just say, I would award it normally, but there are fixed costs of the IPEC. I think there's going to be interest about fixed costs in other jurisdictions later on. There's the cost cap. IPEC is subject to its own reason. And because it's already been found in an early decision back in 2018 that we don't go outside those cost caps, I can't award interests on those costs. So there, if you like, are the procedural issues we're looking at today in cases that have been happening this year. But there's a very interesting batch of cases we'll look at now where it was found that although a party had beaten, or not beaten their Part 36 offers, the Part 36 consequences didn't apply. And that's because those offers were viewed as tactical. And first of all, we have a case where there's an offer 7 pence less than was being claimed. In the case of Crowhill, brought an action for damages. The claimant made a Part 36 offer of 4.937 pence less. The question was whether the claimant was entitled to normal order of Part 36, having beaten their own offer. And what the judge said was, yes, it's conceded it's least advantageous. The claimant's entitled to the award unless the court considers it unjust to do so. What I find was that the reduction of 7 pence was tantamount to asking the defendant to completely capitulate the position and was not a genuine offer to settle proceedings. No real opportunity for settlement, and I'm not going to award the additional awards, benefits of Part 36. 7 pence doesn't cut it. And we look at a case where there's a 4% concession as to damages. The claimant had made an offer to which over 96% of the principal claim should the Part 36 consequence apply. The defendant said, well, this is a tactical offer, it shouldn't apply. And the judge said, all Part 36 offers are made for tactical purposes. An offer, which is a cynical attempt to manipulate the Part 36 regime and apply pressure on adversary, is unlikely to be effective for such purposes. In this case, the claimant had a case that was not strung. We can see why there was argument. And a discount of 1% is meaningless in such contexts. It amounts to saying, pay up now, except you're wrong. It's not a genuine attempt to settle. I conclude that the Part 36 offer was not a genuine attempt to settle these proceedings. There was no impropriety or disingenuity, it just wasn't genuine. And the test I had to apply, says the judge, was it unjust to disallow a claimant's expectation of Part 36? I'm not going to apply the Part 36 consequences in this case. It didn't create a meaningful chance of settling the dispute ahead of trial, and it was quite clear the defendant would never like to accept the Part 36 offer. This is interesting, I think, because it might be totally different if it was the defendant's Part 36 offer, it was the claimant's Part 36 offer. This is an important point. This judgment, says the judge, shouldn't not be taken as any kind of discouragement to claimants making Part 36 offers. If anything, an encouragement to make offers at a level not so perilously close to the full value of the claim in cases such adversarial intensity. So this, and we'll look at another case later on, shows the point. If you are making tactical Part 36 offers in if you like, an or nothing claim, it's a claim of debt or a quantified sum, well, how low have you got to go to be sure you will get Part 36 benefits? Certainly, there's no golden rule, but we can see in these two examples, 7 pence or 4% wasn't cutting it. And the next case involves a 1%, so not a 1%, a 0.1% concession. And that's Sleaford Buildings. It's a enforcement of the adjudicator's decision. It's clearly all or nothing. You either get what the adjudicator has said or you don't. And we had an offer which was a concession of 0.1%. The judge said, I'm satisfied just to make the order set out in CPR 36. This offer was not a genuine attempt to settle proceedings. The offer, if accepted, requires people to pay the whole principal sum. That's not really much of a concession in all the circumstances. It's not a genuine offer to settle. I do not consider the offer to have been a genuine attempt to compromise the Part 7 claim. I consider it unjust to make the orders in 3617, so the claim doesn't get the Part 36 benefits. And another example, there are plenty of this, the Rena White Lane, the claim of an actress suing for $1 million because she'd not taken part in a film. She made an offer of $900,000, and the defendant said, "We beat the offer." Yes, you beat the offer, but there was no disclosure by a third party, and there were other factors when we couldn't assess it properly. And the judge said no. The disclosure from the third party was the defendant for the witness, had no impact on the cost order. You hadn't given disclosure of certain home records, means you're bearing your own cost of that limited part of the action. But the Part 36 offers is effective and is going to apply. So there, procedural issues, procedural damages relation to the effectiveness of Part 36. So we'll look at it in a bit more detail in a few minutes' time. But the fundamental point is the courts can recognise tactical Part 36 offers. If you're just giving a less than a percentage point, it's not going to work more than likely. And even we've seen 4% held and not to be. If you're making claimants offers, not to be effective. It would be different, I think, if these were defendants' offers. But we'll have to see what happens next year. Another point, Part 36 point in MGS University Hospitals, the defendant accepted a Part 36 offer late. They had to be approved. Seriously injured child. It was accepted. The terms were accepted late. What interest rate applied after the relevant date? And the judge said, I'm not going to award you interest at 8% after the date of the offer on past losses. It's a very significant uplift from the standard rate. And you could have specified this in the offer term, and you didn't. And therefore, you're not getting it. And I don't know if that's going to be effective, even if it was accepted. I'm not quite sure it would be a valid Part 36 offer. There's very little penalty, in fact, for a defendant accepting a claimant's offer late. And perhaps that's some of the rules committee should look at. If you accept late, you're paying the cost anyway. But you're certainly not going to get accelerated interest. If you're a claimant, you can stop withholding your offers. I just worry that then they won't be that part of these offers. Another interesting example, again related to personal injury, is an attempt by a claimant to future-proof the Part 36 consequences. The case of Tabbitt and Clark, and what happened was the claimant was accepting late a defendant's Part 36 offer and said, fine, on the law as it stands now in relation to Quox, I can accept I'm liable to pay the defendant's costs after the expiry of the offer, but I want the declaration that if the law changes later on, I don't have to pay the defendant's costs in the future. So we have a Part 36 offer accepted late, and they can't be enforced. We get the declaration application that the defendant can never enforce the costs. And unsurprisingly, I think the application was refused. If every time a man relied on existing law to arrange his affairs, he was made secure against every change in legal rules, the whole body of law would be ossified forever. And in fact, as it turned out, when the law was changed, it wasn't retrospective. So the claimant is safe. And the other issue in relation to Part 36 I want to look at is Part 36 and costs, Part 36 the Solicitors Act assessments, and in the case of Zurich and Vardags. And if you know, if someone wants their solicitor's cost assessed, solicitor and client basis, then there's a general 20% rule in the statute. If more than 20% knocked off, then the client, the solicitor has to pay less than 20%. The client has to pay. In this case, the defendant's solicitors have made an effective offer. They'd beaten their own offer under the Part 36. But as we've already said, the Solicitors Act itself has the 20% rule. And what the cost judge said was the Act has got a mechanism with the tipping point being 1/5. And so the judge determined that Part 36 doesn't apply to the Solicitor Act assessments because the Act has its own checks and balances, and we can't go outside of that. It would subvert the attention of Parliament, says the judge. So there, and I've done it in 45 minutes, but I can see there's a few questions coming up, are the cases I want to look at this year. So what conclusions can we draw from recent cases? The first, I think the main 3 points are the need for the offer itself to comply with the rules. We're still seeing a lot of non-compliant offers. They are unpayable in 21 days, on a pay you installments. You make a defendant's offer, claimant's offer when you're the defendant. And so use the form as usual, use a pencil offer, but you cannot be imaginative with Part 36 offers. You need to follow the form and the wording and the rules yourself. You can't invent your own because you think it's better than that one that's designed by the Rules Committee. So make sure your Part 36 offer is compliant. Because if it's not, for instance, you're a claimant, you get to try and you've not made a compliant offer, the claimant lost £75,000 and it's lost the additional interest, it's lost the indemnity costs. But, there are big consequences of not having a valid offer. So do make sure that the offer is valid. The next point is the need for care if decided to not accept because of uncertain prognosis. Now, we've seen a case where the claimant was fortunate in that the Part 36 consequences were held not to apply in full, because we don't know whether the claimant would cover their costs, although they didn't have to pay the defendant's costs. And I've got to say, there are a whole bunch of cases where the courts have been far less sympathetic to a claimant. Just because of uncertain prognosis, the courts have said on numerous occasions, not a good reason for not applying the Part 36 consequences. And the final point I think we can extract from today are the courts are not sympathetic to tactical de minimis offers, certainly from claimants. As I said, I think it might be different for defendants. But if you're advising a claimant saying, look, you're going to get £100,000, let's offer them 999. You've got to say, this isn't likely to work. You've got to know the case law. You've got to say, there are case law that says it's not a genuine offer to settle. We have to think about what's the best figure we can take forward in relation to making an offer that is likely to be said to be a genuine offer, and the defendant's going to face the Part 36 consequences. Now, if you're thinking, Gordon, I'm not sure there's more recent cases that you haven't spoken about, the overwhelming likelihood is that it's more than 12 months ago. You go back 12 months, and I just point to the webinars in previous years. They're both all on YouTube. If you're very keen and enthusiastic, you can go and look at those, because they go through the 12 months before those webinars in 23 and 22 and 23. This webinar will be going out on YouTube as well, if for any reason you want to watch it again. Now, I've got some questions, so I just want to have a quick look at those while people are online. I don't understand this question. I don't think Part 36 applies on a summary judgment application. But can you confirm? Simon, do you mind clarifying that? Because if you made a Part 36 offer and then you go for summary judgment, I don't see why it can't apply. I don't understand the question. It may be my fault. Oh, if a defendant wants to include a confidentiality clause in the settlement, can be a Part 36 offer, that the offer can only be accepted if the clause of agreed, is the only remedy to call about with a settlement agreement, the corporation and the confidentiality clause. Martin, I don't know if you got the thing I said at the outset, and so questions had to generally be about clarification of the cases I'm talking about, not a general Part 36 question. And I think that breaks that rule. I would personally think it would, you can't, unless you're going to get it at trial and be guaranteed you're going to get a confidentiality clause at trial, it's difficult to include it in a Part 36 offer. Well, this is an interesting question. Will Part 36, this is citizen and client assessment, will Part 36 apply in a likely event as a common law assessment rather than 74 Act assessment? I don't know is the answer, but I suspect it might. I think it might be affected in those circumstances because you haven't got the Solicitors Act presumption about 20%. There's some more questions, I think, over on chat. People go to chat. Here we go, quite a few, sorry. There's a question here. In effect, in the cases where the offerer made a small concession, does the reverse apply? If the claimant makes an offer which is substantially less than the value of the claim, so low the claimant must beat it. They succeed on issues, say 25% or less. Is that an abuse of Part 36? Thomas, I don't understand the question. Don't let me discourage you from expanding it. If you make an offer which is less of the claimant, less to the claim, I'm not sure I understand the question. The question, Chris Wilson, or everyone, wants to stop the defendant just accepting immediately in that situation. I'm afraid it must have been at a certain point in the course. I'm not understanding it. Victoria, is it possible to get a copy of the slides? As I said, I think that they will be sent out to you, and this will be on YouTube. I'm just going to go back to the Q&A session in case anyone's asked the question. Simon Braun, I think I read this is about the summary judgment. There wasn't a trial and didn't apply. I don't remember that case, Simon. It may well be. It certainly hasn't, I did think, propped up this year. And then there's a couple of people saying thank you. So again, I repeat that these webinars are available. This will be on YouTube. You want to watch it again. Hopefully the slides will be sent out to you. And as I said, this is an annual event now. So I hope to see you next year. I'm glad that other years I've actually gone over time. I finished it with 8 minutes. Oops. I say I feel there are more questions coming up. I'll just a quick look before I say bye-bye, because I like to get them all the way. I know just people saying, there are some interesting questions. Would it be possible to make a Part 36 offer in relation to mediation following Churchill? That's, I don't think you can. I think failing to, Part 36 offer that we attend mediation, I can't see how that could be effective? I can see precisely where you're coming from, Mish. It's a brilliant question. I just don't think that comes within the Part 36 regime itself. I think that's the general discretion as to cost, but you can't make a part of the example saying mediate. It'd be interesting if you could, but I think it is very good. And lots of people saying thank you. I've got a scroll for all of those, and yes, hundreds of people saying thank you. Thank you for the questions. As I said, you know where we are, and I shall see you this time next year. Thank you very much.